you should be able to see the member webinar legal considerations presentation on your screen. So I have a few announcements before we get started. First is thank you so much to our panelists for agreeing to do this. I know it's an unprecedented time, so we're all in this together, and hopefully this will be a great event here. Somehow this is not going to our next one, so I will just make announcements from here. So to ensure good quality, all attendees will be muted throughout the webinar. You can ask a question. If you'd like, you can type that into your question box, and Todd Niemczyk from MHA will be monitoring those questions and is our moderator today for the panel. This webinar will be recorded and made available to all on the MHA website afterwards, hopefully within the week. This webinar is provided for informational purposes only and is not legal guidance. You should consult your legal counsel for advice on any legal matter. This webinar is not attributable for media coverage and should not be used even as background for press purposes. Information in this presentation may not constitute the most up-to-date information. As you are well aware, new guidance is released regularly on this topic. Our panelists today are Brian Niemczyk of Hellmuth & Johnson, Malcolm Terry of Bernick Lifson, and Robin Ann Williams of Arbiter. Malcolm Terry focuses his practice supporting all sizes of business in the area of employment law, including human resources support, contract issues, and landlord-tenant law. He works extensively with issues occurring in the multi-housing industry, including defending property management companies against state and federal Title VI and HUD charges of discrimination brought by both employees and tenants. He also handles all forms of contract and leasing issues for his clients. Robin Ann Williams is founding member of Arbiter PLLC, a law firm committed to representing housing providers in Minnesota and beyond. With more than 25 years of experience in housing law, Robin regularly advises and represents residential landlords in eviction actions, fair housing claims, and other disputes with residents. Brian Niemczyk practices primarily with Hellmuth & Johnson's litigation group and focuses on commercial, landlord, tenant, real estate, and employment litigation. He also draws upon his litigation experience to counsel his clients on methods of avoiding litigation in the first place. Welcome to our panel.
Thank you.
Good afternoon.
Thank you. Great, thanks for the introduction, Aubrey. This is Todd Niemczyk. I am with MHA, and I will be moderating today's session. Thank you, panelists, for participating. We are getting a lot of calls, a lot of emails about some of these questions that we're going to talk about today, so we greatly appreciate it. First, I have a list of questions here from some folks that have sent in some questions beforehand, and we'll go through those, and then anyone that sends any questions in now. The first question is the only one that I feel somewhat equipped to be able to handle, and that is, what loans or grants will be available to landlords suffering rent loss? What resources are available to rental property owners to pay taxes, insurance, utilities, mortgages, if rent doesn't come in to meet these expenses? So, as we all know, there are continuing obligations for housing providers that do not go away because of an eviction moratorium. But I'll go through a few of these, and our panelists have others that would be greatly welcome as well. The first one is could be a relatively large one out of the CARES Act that recently passed. $350 billion of that, the CARES Act, was dedicated to small businesses. And the biggest portion, I think, for our industry is the Paycheck Protection Program, which essentially allows small businesses, which are defined as those 500 employees or 500 or fewer employees, can access what equates to 2.5 months worth of your average monthly payroll. And that is if you do not lay off or reduce the pay of any of your employees, you can access 2.5 times the amount of your average monthly payroll, and you can access that program through a small business administration approved lender, so an SBA approved lender. So I would encourage you as soon as possible to reach out to one of those lenders to access those funds. Another program is called an economic injury disaster loan, which the Small Business Administration administers, and that has been expanded to include COVID-19, the COVID-19 crisis as a disaster under that program. And you can access up to $2 million of a loan, some of which is forgivable. I believe at least the first $10,000 is a forgivable loan, but that is administered by the SBA itself, and you can access that directly online. One other program, actually two other programs. One is just deferring the employer side Social Security payroll taxes until 2021, the end of 2021, and then the other half 2022, which is not a huge benefit, but it could be beneficial. And then employee retention tax credit, a tax credit if your gross receipts for the first quarter are 50%, greater than 50% less than what they were in the prior year, the same quarter, then you can access a tax credit that would be a credit on your tax obligations. And another big one is in the CARES Act. Not only was there an eviction moratorium, which for federally backed loans and others that essentially affordable housing, there is a mortgage forbearance provision too. So if you have a federally backed loan, either multifamily or for 1 to 4 units, you can seek mortgage forbearance, and that is up to 90 days for multifamily and up to 180 days, which can be extended beyond that for those that are 1 to 4. Beyond that, the only other thing that I'll mention is people have asked about property taxes and whether or not there will be a property tax deferral or there will be a delay in property taxes. We've had discussions at the legislature, and that doesn't seem to have much appetite for folks there, simply because local governments have their obligations they have to continue to pay. However, there has been discussion, and there is statutory authority to this, that county boards don't have to institute a penalty for late payment of those property taxes. So I think we'll be hearing more about that as we get closer to that May 15th property tax due date, that some counties will be discussing that the penalty may be waived for a certain period of time. So those are the items that I wanted to touch on. Now I'll hand it over to you guys.
I just want to add real quick about the payroll protection loans. I've gotten a lot of questions from clients about those, both in the landlord industry and otherwise. And I've directed clients mostly to various commercial bankers, or told them to go to their own commercial banker for the details and the applications and things like that. I've heard anecdotally that there are delays and problems, and there are some banks who aren't giving those loans to anyone but their own customers. They're pre-existing customers. So if you have a pre-existing commercial banking relationship, that's the person to start with, and that's the best person to get the information you need to see if you qualify for that, if it makes sense for you. If there's a chance that sort of program could help you. I'd go to your commercial lender first, and if you don't have one, you may have difficulty finding one that will do these sorts of loans, but it's certainly worth a shot because it's an excellent program, or at least it sounds like, assuming the bureaucratic hurdles can be worked out.
Another interesting thing about this loan is actually there's some indication that you can use the loan to cover severance payments. So if you're separating from an employee and you're going to give them a separation agreement, that severance payment is most likely going to be deemed covered by the PPP loan.
And one thing, I'm not positive that I mentioned this when I ran through it the first time, that is potentially a forgivable loan as well. The details are a little bit unclear, and I think part of that will be determined by how quickly they run through the resources, but that there is at least some of that will undoubtedly be forgiven if you qualify under that program.
Yeah, I think payments are even deferred for 6 months. So it's a program meant to provide immediate help for businesses who need it.
Yeah, a lot of people are trying to figure out how the loan works, but the long and short of it is if 75% of that money is used for payroll, and the remaining 25% is used for, I think it's utilities and your own rent for your space, you'll fall into the category of being forgivable. I would recommend just using it all for payroll, earmarking it that way so that you don't have a problem. And if you've laid off anybody that you questioned laying off and you want to bring them back, certainly bring them back because that money will help support them.
Great. Long and the short of it is people should access it ASAP. Why don't we move on to the second question then? How do we collect rent from behind tenants without running afoul of the executive orders? How do you address people asking to, quote, skip paying rent?
Well, the executive order, go ahead, Robin.
First of all, the first message to our residents is neither the federal law nor the state executive order says that residents don't owe rent. They do owe rent. The rent is not forgiven for any period of time. So the first message to residents is rent is still owed. I think to avoid landing on the front page of the Star Tribune or becoming an NPR story, and I heard the NPR story last night about a landlord in northern Minnesota who decided to turn off the electricity of his residents allegedly in order to get them to move because they weren't paying rent. Of course, that was against the law even before all this. That would be a lockout. We don't do that. But I think that you want to be clear in communication with residents. They still owe the money. I would not harangue them. I would not badger them. And the bottom line is once the federal stay exhausts for non-payment, which is going to be July 24, if you are covered by the CARES Act, and that's going to be any affordable housing program under VAWA. It's also going to be any federally administered or federally insured or federally backed loans. So there's Freddie Mae, Freddie Mac, lots of loans in there. We're not going to be able to do anything about non-payment until the July 24 deadline passes. If you have a federally backed loan, if you don't have a federally backed loan, we're not going to be able to do anything until the governor lifts his stay. A lot of my clients are being very proactive in asking residents to tell them if there's a problem and they're not able to pay their rent. A lot of my clients are being very proactive about very generous repayment plans, because the bottom line is, especially if you have a federally backed loan or if you are federally assisted in any way, there's not going to be much movement, if any movement at all. Actually, there's not going to be any movement until July 24 comes and goes.
Yeah, the governor has actually also specifically indicated that rent is still owed. In fact, the governor's order 20-14 specifically says nothing in this executive order relieves a tenant's obligation to pay rent. So if you've got tenants that aren't paying rent, or, well, as Robin said, the best thing you can do is to reach out to tenants, especially if they haven't paid their rent on time. Get with them, talk to them, and try to work out some kind of arrangement. As Robin indicated, a lot of the property management companies are doing that anyway.
I've had some questions about whether, now keeping, there's the executive stay that applies to every landlord in Minnesota. That applies to any kind of eviction action right now, unless there's endangerment to another resident, a serious endangerment, or unless there's a violation of the covenant not to allow activities, unlawful activities. So under the federal or the state governor's order, everyone's stayed on non-payment cases right now. And under the federal order, the federal law, all federally backed programs, loans are stayed. I've had a lot of questions about whether a resident has to establish a tie between COVID-19 and his or her inability to pay rent, and the answer is no, as Brian and Malcolm just indicated. The answer is no. That you can't make a resident show you that she can't pay her rent because of COVID-19. So on that
Great.
cheerful note, what's the next one, Todd?
The next two questions are somewhat related, but we'll read the first one related to employees. So if a maintenance employee tests positive for COVID-19, are we obligated to notify residents in general of the infection, or only the residents the employee had recent contact with? In other words, they performed an emergency work order in the residence unit. Why don't we start with that one, with the maintenance question?
Yeah, I'll address it. I saw this question. I kind of looked it up and, seemed to find a lot of great law that would directly apply to the subject. But the guidance that I was able to find was that you should send such a letter out that contains absolutely no identifying information of who the person might have been, that tested positive or that otherwise has indications that they may be sick. A letter saying that someone has tested positive, that the landlord is taking all necessary precautions to make sure that that everyone stays healthy, that you should be aware of this, and that if you ever feel sick, that this is something you should take care of. That's the guidance I've seen out there to various and from various landlord groups. I'm not aware of any specific law that the word obligated is used in this question. I'm not aware of any specific law that obligates you to report these things to other residents, but it's a very good idea in my opinion.
Yeah, you have to be careful too, because as an employer, you're receiving information about the medical condition of one of your employees, and that's covered by some federal laws as to what you can and cannot reveal and to who. I think the smart move would be to, as Brian suggested, send a notification or letter to your residents. But I would just indicate that somebody in the building has tested positive for COVID-19. I wouldn't necessarily say it was an employee, because now you run into some HIPAA issues as well as some other issues.
I can also point folks to the Minnesota Department of Labor and Industry. They have, I don't know if you guys can see this, I printed it this morning because I'm not an employment lawyer, but I do play one on TV, especially today. And this is a document that the state of Minnesota is keeping up to date. It was last updated on April 1, and it talks about specific employer questions and specific employee questions. I think it's a helpful document. To Terry's point, apparently the EEOC has released some temporary guidelines stating that employers are presently allowed to ask employees if they have symptoms of COVID-19. Usually as an employer, you can't ask about an employee's health, but the EEOC has relaxed that. But definitely I agree with Malcolm and Brian that even if we're able to inquire about whether our employees have symptoms, and even if one of our employees becomes ill and we want to notify residents about it, I completely agree. Do not identify your employee in that communication.
Let's move to the next question, which is the next logical step is, what is the landlord's responsibility to residents if a confirmed case is discovered in the building? In other words, a resident is infected with COVID-19.
Just as I'm not aware of any federal or state law or binding directive right now that says we would have an obligation to advise residents if one of our employees is ill with COVID or if another resident is ill. And if Brian and Malcolm, if you know of specific directives on that, please feel free to correct me. But assuming there's not a specific directive, I think it's up to you as the housing provider to decide if you want to tell residents that another resident has fallen ill. Some of my clients, depending on the building, they don't want to do that because they're very concerned about folks in the building becoming very concerned about it. And I'm speaking about situations where you might have highly vulnerable populations living together. And a lot of my clients do want to make that disclosure and follow the same rule. We're not disclosing the name of the resident. We don't need to turn this into a witch hunt. But if we want to disclose it, we voluntarily can. Just keep confidential who is ill. I would also assure folks, because I'm assuming it's true, that the person is self-quarantining. And even though we aren't required to do it, go out with your Lysol wipes and your Clorox wipes and wipe down doors, et cetera, where you think the person's been. Speaking of Clorox wipes, I am accepting payment in that form right now. So if any of my clients are listening, you can pay your bill in Clorox wipes.
That's what we've come to. Next question.
Hold on a sec. It's actually a pretty complicated question, because if you run a scenario and think about it, so you have a tenant that's got COVID-19, you know they're self-quarantining, they're in the building, but they've obviously been in the common areas while they were infected, and the landlord knows. Does the landlord give some level of a notification to the rest of the tenants? And if they don't, and another tenant gets infected because of it and becomes seriously ill, or maybe even dies, some very friendly plaintiff's attorney going to end up suing you? That's a complicated question to get into. I have a feeling that plaintiff's lawyers are going to be circling quite a bit when all of this is done over a lot of the regulations and issues associated with this. I would just go back to the answer that we gave for the previous question. If you know somebody in the building has it would probably be a good idea to circulate a notice to the building indicating that somebody that has been tested positive has been in the building. I wouldn't get a whole lot more specific than that. And if that happens, I would urge you to call whoever your lawyer is that you work with and have a conversation with them about that.
Right.
I
Next question.
also hope it related to common areas that everyone's common areas are now closed down. Obviously, we can't close down common hallways and elevators and things like that, but it is a fool's mission, in my opinion, if you have a fitness room that's still open, or if you have any kind of, grilling area, kitchen area, et cetera, those should all be shut down right now.
Yeah, I agree with Robin. Amenities should be shut down. I've talked to several clients about tenants who have complained about having to pay their rent or their full rent when the amenities are shut down. Most of your leases will have a clause in there that talks about the use of the amenities and how they can be regulated. If you use the Blue Moon lease, the NAA lease, which is probably one of the few times you'll hear me say something positive about that lease, it actually addresses this question very, very well. And it specifically indicates in the addendum that your rent, the amount of rent that you pay is not conditioned on the availability or use of the amenities, and that you can close them down. But I think everybody's lease has some level of language in there that you can utilize to avoid that issue, because it's been coming up.
The other thing that's, we can't go to court right now for just about any kind of eviction unless someone is, jeopardizing someone seriously or is violating the covenants not to allow unlawful activities. But that means your tenants can't go to court either. So they can't bring a rent escrow action right now to try to enforce any kind of claim that they think they should be able to use the fitness room right now.
Unless it's some kind of emergency issue, and that certainly would not qualify.
Right, of course. But I don't think use of the fitness room is an emergency.
No.
With regard to, as Robin indicated, your amenities being closed down, but you can't do anything with the hallways and the common areas. To the extent you're working with a professional company that can come in and do some kind of bacterial or antibacterial or antiviral cleaning to help maintain those common areas on top of what your maintenance people are doing, that would probably be a good idea too. At the end of the day, we want to keep everybody safe that's in these apartments, because they're somewhat living in a honeycomb, and we want to keep them as clean as possible.
And of course, your employees.
Yeah.
The folks who have to deal with them.
I agree with Malcolm that I think that plaintiffs' lawyers may try to hold housing providers responsible if someone gets sick because we didn't clean the elevator panel. I think they'd have a tough time under Minnesota law because there's no special relationship between a landlord and a tenant in most instances to keep the tenant safe. But, one of the things that's great about America is that you can bring a lawsuit. And I think that Malcolm is right that there might be a lot of lawsuits. So do the right thing ethically, do the right thing legally, try to keep your common areas as clean as you can.
Great. I'm going to move us along. We have a number of questions rolling in too on the website. So how do we ensure fair application to delinquent rent payment plans when each tenant's financial situation will be so different? What do we do in place of evictions for renters who have delinquent balances that continue to increase?
I'll take the first question, the fair application question. Of course, you can't treat tenants differently because of their membership in any protected class or anything like that. But if they have individual financial circumstances that you've talked about with them and they differ from their neighbors, You certainly can set up different payment plans or treat their non-payment of rent in a different way, as long as it's based on actual differences in their financial situation. So if you have decided you're going to, have a general policy of deferring rent for some period of time if someone asks, and you decide then that you're going to do something different for some particular tenant, as long as it's because of their individual circumstances and not any sort of protected class reason, you have all the discretion in the world to do so. So, I mean, the general advice is to, is the same as we've kind of talked about before, have individualized conversations with your tenants about their current financial difficulties, if any, and, adjust to them, adapt to them, accommodate them in a rational way that takes in those individual differences into account. And you won't run afoul of the law by doing so.
I'd agree with Brian.
Same.
All right.
As for the second part, I think that's just building on what we talked about before, which is, we're not going to be able to move folks along who are not paying their rent right now by filing an eviction action against them. So I'm recommending martinis after 5 p.m. or something like that to help you with the stress. And I'm not being smart. I am being smart, actually, but I understand lots of clients are very frustrated right now, but our hands are tied. We can't bring an eviction action based on non-payment right now.
Right.
Yeah, it's a complicated, again, situation. I've actually responded to an email from a tenant today, a client today who was very upset about a tenant that hasn't paid their rent and some of the things they're doing. It's tough. We are kind of in a position where our hands are tied. And as I think it was Robin indicated, there's only 2 reasons under the current governor's order that we can bring an eviction, one of which is the crime-free, drug-free provision of 504B. And even then, my office is having trouble getting those hearings set in Ramsey County right now without requiring us to bring an emergency relief request, which has a completely different standard than the 504B 171 crime-free, drug-free provision. So the best you can do is just try to work with them. At some point, we'll be out of the tunnel, and then we'll just have to address the issue then.
I will also add another kind of disconcerting part of the governor's executive order is we can bring an eviction action right now if a resident seriously endangers another resident, or if the resident violates the covenants not to allow unlawful activities. It doesn't say serious endangerment of staff. So I think that was an oversight. And certainly if I have a resident who's acting in seriously endangering a staff member, I will try to extrapolate that and say that by definition threatens other residents as well. But that's a bit of a hiccup in the law, in the executive order. So if you're experiencing a resident who is threatening your staff, you need to consult with legal counsel to see the best way to position that case to see if we can bring an eviction action.
Yeah, thanks for pointing that out, Robin. That's something after the executive order was issued. We had a conversation with the governor's office, and they agreed in principle, and we've had conversations about amending the executive order, but that has not happened.
Well, keep in mind,
I understand why the governor is doing what the governor is doing. I mean, obviously these are unprecedented times and we don't need a lot of people who are homeless who have coronavirus. I understand that. But every time I listen to the governor's press conference, he reminds residents that they can call the attorney general if their landlord is violating the stay. So I think it's, unless you want to be on the front page of the Star Tribune, we need to be very careful and make sure that we don't violate the stay right now.
Yeah, if you have a tenant that's threatening an employee or even an altercation with an employee, definitely call the police. That's still a crime, depending on exactly what happens, and could be a basis under 504B 171 to get them out. But yeah, if your safety is at risk or you're anything, call the police. They're still out there. They're still doing their job.
Next question, what are the OSHA requirements for staff that are on the front lines, so caretakers and maintenance?
So I looked this up too, and the first place that I'll direct people is there's a web page and a set of specific directions that have been put out there by Minnesota OSHA that are general to every workplace. I couldn't find anything specific to maintenance workers or anything like that, but I think that you know, if you go on the Minnesota OSHA website, there is a nice 2-page, these are the COVID-19 requirements that we think need to be met in order to meet an employer's general requirement to create a safe workplace. And they're the sorts of things you might imagine. You know, as few people as possible in the workplace, as few people as possible actually, you know, being within 6 feet of any other person, lots of cleaning, lots of training, personal protective equipment provided where needed and appropriate and even available. You know, these sorts of other common sense things you've been hearing at every single one of those governor's press conferences from either him or one of his commissioners about making sure that any place is safe. But employers do have a duty under the OSHA law to protect employees from known risks. And there is some specific OSHA guidance on the OSHA website that addresses that. And I encourage everyone to take a look at that. And it's the sort of things you might expect, but it's something to take a look at if you've got any questions about that topic.
Yes, this is another interesting. It's another interesting area too, because OSHA is generally designed to keep a safe workplace for the employees. It's generally because of the conditions in which they're working. You know, COVID-19 is something that isn't necessarily a workplace environmental issue, but it's something that's finding its way into the workplace. So I think OSHA is trying to figure out a good way to deal with it as well. But I saw that on the website too, and it's actually pretty informative.
Yeah.
Great. Related to that, how do you handle workers' comp if an employee tests positive for COVID-19 and state they got it at work?
Yeah, there's been a lot of talk around this issue, and there is a similar to what Malcolm just said. You know, workers' comp, generally you're dealing with things that were, you know, accidents or injuries that obviously happened in the workplace. You know, here someone says, well, I got COVID-19 and I think I got it at work. I'll be like, well, really, you know, you could have got it anywhere. So as I understand it, there's a presumption for certain workers, you know, EMTs, first responders, healthcare people, that if they get a disease, they got it at work. But that presumption doesn't apply to the employees of landlords or property managers. So if someone fits the description in the question, they come down with COVID-19 and they apply for workers' comp saying, I got this at work, they're going to have to prove that. And it would be like, I got this at work from John Smith, the resident, and I know that because, and I think that's highly likely, because I went into John Smith's apartment and replaced his light bulb and did a maintenance request or something like that, and I think he coughed on me or something. You know, the employee, at least, you know, as I understand how the law generally works, would have to prove that. How that will work in practice as people start making those claims and the workers' comp department starts to actually deal with it, I wouldn't start to try to predict. But in any other disease scenario, you'd have to come up with some pretty good proof that you didn't get it just walking down the street or going into some other place of business. You got it from work, and they'd have to prove that like you'd prove anything else. So it's something that you should follow OSHA requirements to try to prevent. But if someone really does apply for workers' comp, your workers' comp insurer may try to fight that and see how that goes. But I don't want to predict how that'll go, but the employee will generally have an uphill battle.
Yeah, that's quite frankly, that's something that's really developing right now. There's not a lot going with it. I agree with everything Brian said. It's kind of we're gonna have to wait and see where that goes.
And can we just use Brian's and excellent comments as kind of a launch pad to talk about what we think we should be telling maintenance workers? I don't think there are many leasing agents going into units right now. I think leasing showings have been canceled in most instances. But, you know, what do we want to say to our clients when they have their employees who need to go into someone's unit? And I think we're not going to pull a fair housing claim if we ask a resident, do you have symptoms of COVID? I think it's appropriate to ask a resident before going into the resident's unit if the resident has any symptoms of COVID. I think it's appropriate to tell the resident that he or she needs to stay at least 6 feet away from the maintenance worker when the worker comes in. The worker is going to need to sanitize the space where he or she is working before and afterwards. I think if you have a ill resident and you have an emergency maintenance request, it is appropriate to say to that ill resident, you need to be in your bedroom behind a closed door or in another room behind a closed door while we're in the unit. Those are some of the ideas I have. Brian and Malcolm, I don't know if you have any others that you've been giving folks.
Boy, if you've got an actually ill resident, you know, unless it's, you know, the gas leak or the leaking pipe or something like that, you know, I just, you know, do absolutely everything you can to defer that.
Absolutely.
You know, if they're just insisting or something, then, you know, maybe a phone call to state health authorities or you know, just because, you know, your maintenance people, you would need some heavy duty protective equipment to really be, you know, free from the possibility of infection by going into someone's house who's actually in her apartment, who's actually infected. And, you know, you may run into employment issues or workers' comp issues or things like that if you allow them into that apartment.
Yeah, thanks, Brian.
Yeah.
I mean, I think the first rule is defer, 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 but if you got to go in there to fix something.
Yeah.
Yeah, if it's something simple, actually, one of the things we've done with our clients is if it's something simple, like they need a light bulb or they need something installed that they can do themselves, to just leave it at the door and let them do it themselves. If it's an emergency issue, like they've got a leak or an HVAC problem or something like that, then you got to go in and just take the precautions you can. Wear rubber gloves, wear a face mask, go in and be clean, and then clean when you leave.
All right. Then the next question I think we've touched on, do owners and managers have legal responsibility to keep common areas germ-free by wiping surfaces, et cetera? Do you have anything more to add on that topic?
Only the germ-free is kind of unrealistic, but the same OSHA requirements and shut down the common areas that don't need to be open, especially the ones that would draw crowds, and the ones that do need to be open, hallways and stuff, follow those OSHA requirements about keeping, wiping them down and keeping them clean to the extent that you reasonably can, as an extension of your OSHA requirements for your employees, if for no other reason. There are other reasons, of course, but on the legal side, it's because of your OSHA requirements.
All right, and the next one, Robin, you sort of touched on this. How do you handle tenants that have given notice to move? Their units are listed, but they don't want their units shown? Are you encouraging your clients to show their units?
Well, I have to confess, I don't know if I have any clients right now who are doing actual in-person showings. I have clients who are doing virtual showings. I don't know of anyone who's doing folks who are doing in-person showings. So if I had a client who was insisting on an in-person showing and I had a resident who had given notice to get out but didn't want us in the unit, I suppose, help me out here. Can I use a lifeline? As a Brian and Malcolm. I'm not very interested in barging into a resident's unit who's not very interested in us being in the unit right now, to be honest, just because I think of the Star Tribune. And I don't want to be on the front page of the Star Tribune.
Yeah, Todd, was the question accessing a tenant's unit for purposes of an inspection or otherwise? And the tenant doesn't want.
It was for a showing.
Okay, yeah, I would agree with Robin. There's not a lot of showings that are going on right now. I mean, it's weird because 504B allows the access for the showing, but I mean, if you've got a tenant that's sitting in there going, no, I'm a high risk individual, I don't want you in here, I'd probably lean towards accommodating that tenant's wishes. As I said earlier, I'm convinced there's gonna be a lot of plaintiffs' lawyers circling around when we're done with the end of this tunnel. And there's no reason to push that issue because you've got apartments that are similar to that apartment. You can show them. You can do a virtual tour. You've got a model most likely. So I'd probably let the tenant have their way in that case.
Hopefully you've taken some good pictures that you can post on your website and do a virtual tour.
Yeah.
So off of the list, here are some questions that have come in. If tenants choose to have company coming in and spending the night or coming to visit, can we ask them to stop doing this as a health and safety issue for others in the building? PCA services and home health aides, they're acknowledging that those are sort of separate issues. But what are your thoughts on visitors and banning visitors?
So, of course, when we sign a lease with a resident, they are given possession of the unit, and that includes their ability to have guests. And I think at this juncture, absent government authority that tells me I'm allowed to suspend all visitors, unless I have an extremely unusual situation, like assisted living, which of course those have already said no visitors, I don't think I would ban all visitors. I've had clients put signs on doors that say, this is a senior facility, do not enter if you are sick. We can hang up general signs like that. I don't feel comfortable banning all visitors just yet, but if Malcolm and Brian are, then maybe I'll start.
No, I think you kind of hit the nail there, Robin, that they have a lease that entitles them to a possessory and use right. If you start taking that away, you know, do you start running afoul of the quiet enjoyment use? Maybe, maybe not. But until there's some kind of an order from the governor or otherwise that says that just people can't get together and they need to stay in place, period, I don't think you can tell a resident that they can't have guests come over.
And if you, I mean, I guess that raises a possibility if you really want to go down that road. I mean, there is a stay-at-home order, and if you think that people are not staying at home and are congregating at in one of your building's apartments for reasons that aren't allowed by the governor's order, I suppose you could report that to, you know, the governor's order, I believe, has like a phone number or other resources to report violations of the order. You could report that and see what happens. And perhaps there's either persuasion or some sort of legal action taken to prevent that from happening. And you could even, you know, put out a notice that says, we strongly discourage this. Here's the governor's order. You got to comply with it. If we see that you're not complying it, or if we think you are, we might just call the authorities.
Right, but I think it's a voluntary order right now, and until it becomes a mandate, I mean, certainly Brian's right. If you've got somebody that's got traffic coming in and out of their apartment, it definitely might be worth a call. But
yeah, see what happens. I mean, I don't know how voluntary you know, it depends, I guess. But you can always do that, or at least threaten to do that, and see what happens.
I mean, I suppose depending on how bad it gets, at some point you might be able to argue that it seriously endangers other residents. You know, if someone has their dear Aunt Sally walking down the hallway coughing up a storm every other day, then we could argue that that person is seriously endangering other residents. I've had, I don't know if Brian and Malcolm have had this yet. I think I'm onto my 4th case of coughing and or spitting on other residents and saying things like, now you'll get COVID. We're taking the position that that's seriously endangers other residents, and we are starting to bring eviction actions for that. But I think it had to be pretty extreme conduct by a guest before they seriously endanger others.
Next question is a callback to the Paycheck Protection Program. Under that program, do I only report full-time employee wages, or are all wages reported for the last 12 months? I would say check with your SBA lender. I believe as far as the 12-month time period, I think it's total of the last 12 months, calendar year 2019, and then take the average monthly payroll, which I think does include part-time employees. But I would check with your SBA lender on the specifics.
I think it would include them because I know you can average out seasonal workers, but I would agree with Todd. I think that's something that needs to be followed up on, because it doesn't specifically say it can't include them. It just says 2.5 times your average monthly payroll cost from the prior year. And then, like I mentioned, it tells you how to figure it out for seasonal workers.
Here's another question. What if someone has reported symptoms but hasn't tested positive? Should they be treated the same and people notified? So someone, so say a resident is showing symptoms, and this gets at some of the comments that we had made before. They're showing symptoms, but they have not tested positive, and we all know that there are delays in the testing. So should they be treated the same as if they have it? And I think that on the maintenance side or on the employee side, what I've heard from some of our members is that they are encouraging all of their employees to treat everyone as if they have it, and every interaction that they have with others as if they are at risk of exposure. So what are your thoughts on this question?
Yeah, I don't see any reason why someone who has COVID-like symptoms but hasn't been tested positive, which I think applies to, thousands, tens of thousands of people in the state of Minnesota alone, would be treated any different. That, if you want to send out that letter, the notification that says someone here, except you don't say they've been tested positive, but they've, exhibited symptoms consistent with COVID-19, and so blah blah blah. Same thing. From the notification side, I wouldn't treat it any differently. I mean, I wouldn't necessarily do it if someone has reported that they had a sore throat at some point. We're talking someone who, it's a very strong possibility that they have the COVID-19 virus, and that you would want to report that the same as if they actually were tested positive.
I'm not clear on who the someone is. If it's an employee, I hope we're telling our employee to go home and not come to work.
Yes, good point. A question about the stay home order. The governor issued stay at home order. Does that pertain to exterior related grounds maintenance? Can the professional lawn care service continue through the quarantine, landscaping projects, and that sort of thing? So, and actually, we sent out an email this morning on that very topic, and it is included. The part of the problem is when you put out an order, there are many professions in an order that you do not contemplate until that comes to light. So they are excluded. So professional lawn care companies are excluded from the exemption, meaning that they are not able to perform their exterior work right now. There is some discussion, and I believe it all relates to golfing, that may change in the future, and golf courses being able to do some lawn maintenance, but that would likely be extended more broadly if that exemption was in there. But as of right now, they are excluded from the exemption. In other words, they cannot perform their work if they are a third-party professional lawn care company.
I frankly have argued for years that yard work is not essential, so I'm glad that the governor finally agrees with me.
Well, here's what's interesting with that, and it may change depending on how long this goes on. In the governor's executive order in section 6Z, which is the one that makes all the property managers critical service, critical sector employees, at the end of it, it says this category also includes workers needed to keep apartment complex buildings and other congregate residences or homes operational and sanitary. If the grass gets a little long over the course of a month or so, is that an issue? What if it starts to get really long? And what if it starts to create health or sanitation issues? I don't know, but I can see where it could become something that needs to be dealt with, certainly over time. But it sounds like Todd has got some up-to-date information on that.
Yeah, and all of this, it's sort of a moving target, as we pointed out at the beginning.
Well, actually, you know what? The other thing too, come to think about it, if we're talking about lawn maintenance services, that's one thing, but most of these companies will do a lot more than that. For example, people have got sprinkler systems. If those systems are operational and they break or they crack or they're damaged, that's got to get repaired somehow. Or
Right.
If they've got a retaining wall that has caved in or is caving in from ice heave or something, that's got to get repaired. So it actually may boil down to depending on what the service is that needs to be done as well.
Here's one. Are laundry rooms included in the common areas, which you should be shut down? So we had talked before about some elements within the common areas being closed.
I would say no, because people have to go do their laundry, and if they can't go to the laundry room to do it, they're going to have to get in their car and go out to a facility. So I would say no, you cannot close those. I would make a big effort to keep those sanitized and clean. As I mentioned earlier, either your staff can do it or you can have a professional service come in and do it, because those services will also document the work that they perform to the extent somebody tries to say you did something wrong as well. So I keep them open and keep them clean.
And limit the number of people who can use them at one time.
Yeah,
Social
that's a great
distancing and big signs that say, one person in there at a time or whatever.
I mean, I think a really big problem with community laundry rooms is when someone does have COVID-19 in your building, because there can be some very bad symptoms with COVID-19 that require people to use the laundry. So, put your thinking caps on if you've got a resident who has COVID-19 and needs to wash his or her bed sheets, about how you're going to handle that. I don't have any bright ideas on that other than, again, Lysol wipes, bleach, sanitize the machine. I love Brian's idea about temporary rules that you have to stay 6 feet away from each other in the laundry room, and or only X number of residents can use it at a time. That's a great idea.
Yeah. Here's a question on late fees. I can't ask a resident to show proof of COVID-19 impact for not paying rent. However, can I ask them to show proof to avoid paying a late fee?
So that's going to depend on whether you're under the CARES Act, which is the federal law, or not. If you're under the CARES Act, which is any kind, if you have to comply with VAWA, you are under CARES. If you have any kind of federally backed or assisted mortgage, you are under CARES. Under that law, you cannot charge late fees from March 27 through July 24. And I think if you have a no mortgage or a completely private mortgage, there's nothing in the executive order from the governor that says you can't charge late fees. You just can't evict anyone who's not paying their late fees. And the only other thing I would add is many of my clients are waiving late fees right now as a good faith showing that we're all trying to help society along during the pandemic.
Right, and MHA put out guidance right before the executive order on the stay on evictions, and that was our guidance through the end of May, that there be no late fees. We specifically said directly related to COVID-19, but these are unprecedented times, and it's we were talking about that earlier today. It's hard to know where the quote impact of those affected by COVID-19 starts and ends, because businesses all across the board are being affected and impacted, which impacts employees as well. One final question that I have here: what if upper management is not taking this seriously and doing nothing? And I'm not sure exactly what that means, but I assume we can speculate.
Well, if it's, we're talking about employees, I assume, and I'll address it at least from that perspective. You can and should exercise kind of internal reporting methods to bring any issues regarding safety or health of employees to the attention of the appropriate HR people, the appropriate upper management people, and apparently that hasn't worked. If it hasn't, you can make reports to OSHA and say that, hey, these are the requirements of the law for a safe workplace, and my employer is not following them. If you do that, OSHA will do an investigation, and you have protections against retaliation for making that good faith report. So there is a reporting mechanism if you feel there's been, your employer is not taking the right steps to keep employees safe.
Yeah, my reaction was, wow, I had to think about that for a minute. You can also make a Department of Labor complaint too. There's a few places that you can complain OSHA, the Department of Labor. Yeah, I don't know why upper management would not take it seriously, especially when the governor's issuing orders about this.
Yeah, for the deciders on the call, we already have a very difficult political environment as housing providers. And if there is a perception that our industry is not taking COVID-19 seriously, that just makes our lives even harder than it already is. And, I would just encourage people who are the deciders in the room to take reasonable steps to help protect employees and residents.
Yes, absolutely, absolutely. Well said, all three of you.